Welcome back. This is your feel-good breakfast show, Expresso, on SABC3 on a Wednesday morning. Now, it was a tense day in court yesterday as defence advocate Barry Roux and prosecutor Gerrie Nel came head-to-head once again in the Supreme Court of Appeal in front of 5 judges who will decide whether former Paralympian Oscar Pistorius' conviction of culpable homicide should be converted to that of murder. Now, Pistorius, who is currently under house arrest in his uncle's home, could be back in jail if he's found guilty of murder. And with us in studio to analyse the day's events is the chairperson of the Law Society's Criminal Law Committee, Mr. William Booth, our expert. Always good to see you, sir.
Great.
Now, I was following the court case on social media, and what seemed to come through from all of the reporters there is the fact that, of course, the big question of the day is that was dolus eventualis correctly interpreted and then applied to the facts of the case, and how this might then turn out in terms of what prosecutor Gerrie Nel is saying is his chief argument. What exactly is his chief argument?
Well, that Judge Masipa did not interpret the whole issue of dolus eventualis properly.
Yeah.
And I think during the hearing yesterday that some of the judges dealt with that and said that, when she, during her judgment, discussed the issue of dolus eventualis, she actually got it wrong, the whole definition. But you've got
What is that definition? Just for some people who might just be catching up to the case now, what does it mean?
Well, that somebody, the accused person, must have foreseen the consequences of his conduct and carried on regardless. In other words, firing 4 shots through a door into a tiny little toilet, realizing that somebody's behind that door and carrying on regardless of what is going to result from his shooting.
So that's not accidental, but rather intentional. That's what the state is trying to prove.
Absolutely. Intention in terms of murder, there, it's direct intention. And there's dolus eventualis. Culpable homicide is the negligent killing of somebody, and that's what he was convicted of by Judge Masipa.
Exactly. I want to get your thoughts on Barry Roux's argument, because that made up quite a big portion of yesterday's case, where he was going back to Oscar Pistorius' mental state. He was saying that he was scared, he was vulnerable, he was on his stumps, and so therefore murder can't be taken into consideration given his state of mind. What are your thoughts on his argument there?
Well, the whole issue of self-defense is one where you shoot, let's say, at somebody, intending to kill them, but your conduct is excused because that person was attacking you or about to attack you, so that you acted in self-defense. If you went beyond what you're allowed to do in terms of our law, in respect of self-defense, well, then self-defense doesn't apply. Obviously, somebody's mental state, what was going through his mind, he'd seen people who'd been attacked in their homes before, other emotional issues, is a relevant factor. But the whole point is, was there an attack or an imminent attack? And on the facts, that's where the facts come into the whole picture. It doesn't seem that there was sufficient grounds to establish that he acted in self-defense. So you take that out of the way, then what are you left with? Intentionally shooting through the door, and that amounts to a conviction, I believe, of murder based on dolus eventualis.
And of course, that would be quite a telling ruling, because that would then set a precedent for all future cases that involve similar kind of circumstances. So just take us through the options that the Supreme Court of Appeal has now with regards to this case as it stands.
Well, look, obviously they'll take time to deliberate on the whole issue. They can, in fact, turn down the appeal. They can say, look, it stands as it stands. He was correctly convicted and therefore correctly sentenced. Or they can say, well, we believe in terms of the interpretation of the law and based on the facts that the judge was wrong. And therefore replace the verdict with one of murder. Then they can re-look at the sentence, because murder is obviously, by definition, as we all know, far more serious crime than culpable homicide. They can either themselves deal with the sentence, because they've got all the facts there. The whole sentencing process, and the witnesses were called in aggravation and mitigation of sentence. So that evidence is all there, so they can re-look at it. They could also send the matter back to Judge Masipa and ask for her to look at the sentence again. But in my mind, I don't see why that should be necessary. It's going to just prolong the whole process. They've got all the facts, and I think they can, that is the Supreme Court of Appeal, can themselves deal with sentence, possibly call on the state and the defence to submit further heads of argument on sentence.
Oh, Mr. William Booth, as always, appreciate your insights. Thank you so much. So that is the latest from our expert, of course, talking about the Oscar Pistorius trial right now in the Supreme Court of Appeal. So the big question on everyone's mind, and I'm sure around the office today, will be who won the battle in the highest court in the land? Was it Advocate Barry Roux or Gerrie Nel? Let us know on our Facebook page. Of course, that is Expresso Morning Show, SABC3, using our hashtag Expresso Show. Right now, let's catch up with the headlines.